You're gliding along, quietly, carefully, helmet on, sticking to the edge of the road like a considerate rider should, and the blue lights appear behind you anyway. The officer walks over, and the first thing they say isn't about your speed, or your helmet, or how carefully you were riding. That's an offence. I'm going to have to seize that. And the confusion that hits most riders in that exact moment is genuine, because in their mind, they own this scooter. They paid for it. They've been riding carefully, responsibly, exactly the way you'd want anyone to. Surely owning something means you're allowed to use it. Here's the fact that catches an enormous number of otherwise careful, sensible people completely off guard. In the United Kingdom, a privately owned electric scooter cannot lawfully be ridden on a road, a cycle lane, or a pavement anywhere, regardless of how carefully, how slowly, or how responsibly it's being ridden. This isn't about reckless riding, or excessive speed, or riding without a helmet. Ownership itself doesn't make it legal to use in any of those public spaces. The only genuinely lawful way to ride an e-scooter in public anywhere in the country is a rental scooter from an officially approved operator inside a specific government-designated trial area, and even then, only under the terms of that specific scheme. Get this wrong, and you can lose the scooter entirely, face a fine, and in some circumstances pick up points on a driving license for simply riding home from the shop on something you own outright and have never once ridden dangerously. Get it right, meaning genuinely understanding where the actual legal line sits, and you can make an informed choice about when and where you actually ride, rather than discovering the true legal position for the first time with an officer's hand already reaching for your handlebars. So today I want to walk you through exactly why private e-scooters are treated this way in law, the calm words to use if you're ever stopped, what genuinely happens if the scooter is seized, and where you can actually lawfully use one. This is general legal education for England, Scotland and Wales, not legal advice for your specific situation, and I'm not your solicitor. This area of law continues to shift, with government trials and reviews ongoing, so always check the current official position for your specific area before assuming anything here still applies exactly as described by the time you're watching it. Let's start with why this rule exists at all, because it genuinely surprises people once they understand it, and understanding it actually makes the whole situation far less confusing. Legally, an electric scooter is treated as what's called a motor vehicle, in essentially the same broad category as a car or a motorbike, because it's mechanically propelled. And motor vehicles used on public roads are required, under long-standing road traffic law, to meet a whole set of requirements, insurance, registration, and various technical standards that ordinary consumer e-scooters simply aren't built or certified to meet. It isn't that lawmakers specifically banned e-scooters, it's that this newer piece of technology arrived into an existing legal framework that was never designed with it in mind. And until that framework changes properly, a private e-scooter effectively can't satisfy what the law requires of any other motor vehicle on the same road. This is exactly why the officially approved rental schemes work differently. Those rental scooters operate under specific trial regulations, with insurance arranged through the operator, technical standards built into the scheme itself, and clearly defined areas where they're actually permitted, which is precisely the machinery a privately owned scooter, however well made, simply doesn't have access to on its own. Here's the trap underneath the confusion, and it's worth naming clearly, because it isn't really a trick in the way most of what we cover on this channel is. It's a genuine, widespread misunderstanding. Because these scooters are sold openly in ordinary shops, ridden constantly and visibly in every town and city, and marketed as a simple, responsible way to get around, an enormous number of owners genuinely believe that riding carefully and legally are the same thing, that as long as you're not reckless, you're fine. The visible, everyday normality of seeing them everywhere does real work here, because it makes an activity that's actually unlawful in public feel, quite reasonably, like it must be fine. So let's talk about the wrong response, because I've seen this exact confusion play out constantly. The confused defensive version of this goes like this. Someone stopped for riding a private e-scooter argues the point at the roadside, but I've got a helmet on, I'm going so slowly, everyone rides these, you can't possibly be serious. None of that changes the underlying legal position, because the issue was never about how the scooter was being ridden, and arguing the wrong point simply uses up energy and goodwill without addressing what's actually being enforced. There's a different mistake too. Someone who, once stopped, becomes hostile or tries to ride off, which can turn a straightforward, if frustrating, seizure into a genuinely more serious situation involving separate offences entirely. Here is the calm, correct approach, and it's slightly different in shape from most of what we cover on this channel, because the underlying legal position here usually isn't in dispute the way it is with, say, a search or a filming instruction. I understand. I wasn't aware this counted as a motor vehicle under the law. Can you talk me through what happens now? That's the whole thing. Notice what it does. I understand. I wasn't aware this counted as a motor vehicle under the law is honest, calm, and doesn't pretend to dispute a legal position that, in the vast majority of ordinary private e-scooter stops, genuinely does apply. And can you talk me through what happens now moves the conversation directly to the practical next steps: seizure, any paperwork, how to get information about it, rather than into an argument that was never going to change the outcome. Let me be completely clear about something important here, because it matters enormously for how you actually respond. This is one of the rare situations on this channel where the calm move genuinely is full, straightforward cooperation rather than politely declining something. If an officer says they're seizing the scooter under their genuine power to do so, this is not the moment to argue, to refuse to hand it over, or to try to ride away, because doing any of that converts a straightforward regulatory matter into something with far more serious consequences attached to it. Now let me walk you through what actually happens once a scooter is seized, because knowing the shape of this process removes a lot of the panic. You should be given information about which pound or storage facility it's being taken to, and in many cases, seized e-scooters follow a broadly similar reclaim process to seized cars, meaning there's a limited window of time to collect it, alongside whatever fees apply, before it risks being disposed of. Ask directly, at the roadside, for the specific details, where it's going, what the process is, and what time frame you're working with, and note it all down properly, the same way you would with any other seized vehicle, because the specific numbers vary, and it's worth having the exact figures for your situation, rather than assuming. There's a secondary point worth understanding, because it changes how you might think about using an e-scooter going forward without falling foul of any of this. Riding a private e-scooter on land you own, or on private land where you have the landowner's genuine permission, generally isn't covered by these public road restrictions at all, because the entire framework we've discussed is specifically about public roads, cycle lanes, and pavements. A private scooter used entirely on your own driveway, in your own garden, or on private land with clear permission, sits in a completely different category. If you want to actually ride an e-scooter in public lawfully, the genuinely reliable option, at least under the current framework, is one of the officially approved rental schemes operating in specific trial areas, used strictly within that scheme's own rules. I also want to address the frustration a lot of people feel once they understand this properly, because it's completely reasonable and worth naming directly. It can feel deeply strange that something sold openly on the high street, marketed as an eco-friendly, sensible way to get around, turns out to be unlawful to actually use in the exact places it's designed for. That frustration is valid, and it reflects a genuine, ongoing gap between how quickly this kind of technology has spread and how slowly the specific legal framework around it has caught up, a gap that government reviews and trial extensions are still actively working through even now. None of that changes what the law currently says, but understanding why the confusion exists, rather than assuming you've simply done something obviously wrong, matters for how you approach the situation calmly, if it ever comes up. Let me bring this together into what it actually sounds like when it goes the way it should. You're stopped, blue lights, an officer walks over, explains the scooter's being seized. Rather than arguing about how carefully you were riding, you say calmly, "I understand. I wasn't aware this counted as a motor vehicle under the law. Can you talk me through what happens now?" The officer explains where it's going and what the process is. You note it down properly, and the interaction ends there, without confrontation, because the actual legal position was never really in dispute, only the awareness of it. Now picture the version that goes wrong, not through any dishonesty, but through genuine, understandable confusion turning into frustration. Same stop, same explanation from the officer. But this time, feeling genuinely wronged, the rider argues at length, insists it isn't fair, refuses to hand the scooter over easily, and the straightforward, if disappointing, regulatory matter turns into something considerably more stressful and complicated than it ever needed to be, over a legal position that, however surprising, was never actually going to change based on how the conversation went at the roadside. There's a related confusion worth clearing up separately, because it comes up constantly and it genuinely trips people up in the opposite direction, and that's the difference between an e-scooter and an electrically assisted pedal bike, sometimes called an e-bike. These are treated very differently in law. An e-bike that meets specific technical requirements, providing assistance only up to a certain speed, and only while you're actually pedaling, generally is treated more like an ordinary bicycle and can lawfully be used on public roads and cycle lanes without needing insurance, registration, or a license. An e-scooter doesn't get this same treatment, regardless of how similar the two might feel to ride, because the legal categories that apply to each are built on genuinely different technical definitions, not on how each one feels or looks from the outside. If you're choosing between the two specifically because you want something usable on public roads today, this distinction is worth understanding properly before you buy, rather than after. I also want to address something worth knowing before you ever purchase one of these, because it would have saved a lot of people from ending up in this exact roadside conversation in the first place. Retailers selling private e-scooters are not required to tell you, at the point of sale, that the product you're buying cannot lawfully be ridden on any public road, pavement, or cycle lane. Some are upfront about this, plenty aren't, and it's genuinely worth asking directly, before buying, exactly where you'll actually be permitted to use it, rather than assuming that because something is sold openly on a shop shelf, it must be broadly fine to use in the ordinary places you'd expect to ride it. There's a further practical point worth understanding, because it affects the actual financial risk involved beyond simply the scooter itself. Because private e-scooters aren't legally usable on public roads in the first place, they generally can't be insured for that use either, which means that if you're involved in a collision while riding one in public, whether it's your fault or someone else's, the ordinary insurance protections that exist for cars and for properly regulated rental e-scooters simply aren't there in the same way. This is worth knowing not just because of the risk of a stop and seizure, but because of what happens in the far more serious scenario of an actual accident, where the absence of insurance cover can leave you personally exposed to costs that would ordinarily be covered for almost any other vehicle on the road. One more thing worth knowing, because it shapes how you might think about all of this going forward, is that this area of law is genuinely, actively under review, not a settled, permanent state of affairs. Government trials of rental schemes have been extended multiple times, and there's ongoing discussion about a proper long-term legal framework for private ownership. This means the specific position could shift in the coming years, which is exactly why checking the current official position for wherever you actually are, rather than relying purely on a general understanding from a video like this one, matters more here than in almost any other topic we cover on this channel. I want to close by saying something reassuring, because this particular topic tends to land differently than most of what we cover, more confusion and mild frustration than genuine fear. Nobody watching this has done anything morally wrong by owning or riding a private e-scooter, and the gap between how normal these feel and what the law actually says reflects a genuine mismatch in how quickly technology and legislation move, not any failure of judgment on the part of ordinary, sensible riders. The entire point of walking through this calmly is simply to close that gap for you, so that whatever choice you make about where and how you ride, it's an informed one, made with the full picture in front of you, rather than one made in good faith on an assumption that turned out not to hold up the way you'd reasonably expected it to. There's one last practical detail worth carrying with you, because it's the kind of thing that's genuinely useful to check before you ever need it, rather than after. Whether an officially approved rental trial actually operates in your specific town or city changes over time as schemes launch, extend, or wind down, and the only reliable way to know for certain is checking current, official sources for your specific area, rather than assuming based on what a friend in a different city has told you, or what you remember from a few years ago. A scheme that exists in one city very often doesn't exist in the next one over, and assuming otherwise is exactly the kind of small, understandable mistake that leads people into this exact roadside conversation with genuinely good intentions, and a scooter that turns out not to be covered by anything after all. So let's bring the whole thing together, because underneath the confusion of that first stop, it really does come down to one simple fact worth knowing before it ever happens to you. A privately owned e-scooter cannot lawfully be ridden on any UK public road, cycle lane or pavement, regardless of how carefully it's ridden, and the only genuinely lawful public option is an officially approved rental scheme within its designated area. If you're ever stopped, the calm, sensible response is honest acknowledgement and full cooperation with the actual process, not an argument about how safely you were riding, because the two were never actually connected in the first place. That combination, understanding the real legal position in advance and responding to any stop with calm, straightforward cooperation, is what separates a frustrating but manageable afternoon from a genuinely serious escalation over what started as a perfectly considerate ride home. If this helped you, do two things for me. Send it to anyone you know who rides one of these, because the sheer number of people who've never once been told this basic fact is genuinely surprising. And it's far better learned calmly now than at the roadside with an officer's hand already on the handlebars. And subscribe, because I break down exactly this kind of thing in plain English, so that the next time something you own turns out to sit in a legal grey area you never expected, you already know exactly where you actually stand.